the right to live with human dignity, which this honorable court has said a bare minimum right to the shelter of the home is there, with the government right to regulate unauthorized colonies. Lordship, inconsistent policy of the state governments. On the one hand, government is coming out with these assurances that all your unapproved, unlawful, illegal structures will be regularized. Page 63, State of Delhi. Page 29, State of Andhra. Page 53, State of Telangana. All are saying we will regularize. And they take municipal tax, they take property tax, they allow electricity connections. And after 30 years, 40 years, 50 years, all of a sudden then they come out, no, this is illegal and we'll demolish it. And we'll demolish it without the least regard whether a person is having 30 yards only for 3 persons, 4 persons, and no alternative accommodation, nothing. So, Lordship, some jurisprudence of human rights has to inform this entire area of demolition, which is done in a very hurried manner, erratic manner, in an unsystematic manner. I am requesting that this honorable court may constitute court-empowered committee to go into such guidelines so that, Lordship, on the one hand, yes, I'm not for unauthorized construction and unauthorized colonies, but at the same time, 30 years, 40 years, 50 years, old women coming, crying, children coming helpless. Lordship, something is to be done by this honorable court.
Already against the illegal or unauthorized demolition, already comprehensive directions are issued, Dr. Surya.
Lordship, those directions are there, but kindly see that those directions with great respect are, with great respect, contradictory. For example, in case of Rachna Sharma, where Chitra Sharma, Lordship, para 25, Honorable Court says, 3 judges bench, Honorable Court says the right to shelter should be considered as a part to right to live with human dignity. On the other hand, as recent as 14 July 2026, another division bench of this Honorable Court, Bimlindu case, at para 21 says, long standing of colonies does not mean anything. You must obey the law. Even where it is compoundable, we will disregard it. So totally contradictory directions are there. So that's why I'm saying, even with the Honorable Supreme Court, on one hand, assurance is given, on the other hand, says time will not create any right whatsoever. Kindly see the strong language used in that Bimlindu case. Give the copy.
Policy. How can we control fear?
The time will not create anything irrespective of the situation. We make it clear for all time to come that mere passage of time or laxity on the part of the authorities in taking timely action will not cure the illegality by itself. Passage of time does not create any right. Lordship, I appreciate it, but kindly see it not from a legal angle, but from a human angle. So, Lordship, I am suggesting that a benevolent intervention of this honorable court in this area through court empowered committee may be.
Takeover demolition issue throughout the country, sir.
Lordship,
You cannot substitute the powers vested in a state or the municipality
Lordship,
to enforce rule of law
Lordship,
to any court empowered committee. It will be completely contrary to the constitution.
Lordship, I appreciate it, but I appreciate it.
Democratic principles. How?
Lordship, then in that case, direction to the central and state governments. In fact, I made
There are,
alternative prayers.
as you rightly said, humanistic jurisprudence
Lordship,
worked out by this court, starting from Olga Tellis.
Lordship, Lordship,
From Olga Tellis onwards,
Lordship,
one in settled possession
cannot be dispossessed without due process of law. Till recently, where this court gave certain directions
Lordship,
that at least a 15-day notice has to be given even
Lordship.
to a rank unauthorized occupant.
Lordship, I bow down.
Instructions.
Lordship,
So these guardrails have already been put.
but they are not followed.
Implementation of those guardrails in a particular case-to-case basis.
Lordship,
For which, sir, we would require to examine them individually, not on a collective policy play.
Lordship, there I am submitting that with great respect, there is a negative guarantee of liberty, means not interfering. There is another positive liberty, as Professor Roscoe Pound and others jurists has impounded, that unless there is a meaningful guarantee, merely having the guarantee on piece of paper will not be enough. For example, even after 15 days notice, if a person has nowhere to go, can't we provide some alternative bare minimum, maybe 15, 30, 40 yard accommodation? Be-
Exactly what we are trying to indicate to you.
Lordship,
There are cases and cases. There are ranked illegal constructions which have been undertaken for profit motivation. There are situations, as you are saying, large number of unfortunately economically marginalized people occupying tracts of land who would require alternate accommodation.
Lordship,
These are policy decision calls. We cannot fetter the state from taking a particular policy recourse. Once it takes such recourse, we can step in through judicial review if that policy is arbitrary, unreasonable, or not accommodating due process.
Lordship, there I am praying. Lordship,
The writ petition is too widely worded and encroaches on policy domain.
You yourself filed two
Dr.
annexures
Singh,
saying.
why don't you first approach the states and the union
Lordship,
for the formulation of a policy?
Lordship,
We can help you to the extent that we can direct them to consider what you have suggested.
Lordship, I should be grateful. I should be grateful.
Ultimately, you please appreciate it's a
Lordship,
policy
Lordship, Lordship,
It's a policy domain.
so grateful, so grateful. Lord, any word from your Lordship will be of great help.
Order and the Andhra Pradesh orders also, they are taking steps in particular unauthorized colony, they are themselves regularizing it. So
Lordship.
that's again a policy from time to time.
Actually,
Lordship,
with the demolition, you are also raising the issue of rehabilitation.
Lordship,
Because you feel that after the demolition, even if 15 days notice, 1 month notice is given,
Lordship,
eventually if the demolition takes place, then where the family goes?
Lordship,
Where
Lordship,
comes-
that
where-
precisely that.
Welfare scheme of the state for rehabilitation. So this is something a twin responsibility that if you want to demolish an unauthorized construction, do you have a policy for their rehabilitation?
Lordship, grateful Lordship. Lordship is so kind.
The Center for Law and Good Governance as a non-political, from a public-spirited academic organization has approved this code under Article 32 of the Constitution through this repetition from a purportedly filed in public interest, seeking direction to the Union of India, from state governments and union territories to formulate a uniform policy regarding regularization and demolition of long-standing unauthorized construction. So for that purpose, the petition also seeks appointment of an expert committee by this court to monitor and supervise the formulation and implementation of such policies. It is inter alia pointed out that state governments across the country have for decades not only allowed unauthorized colonies and constructions to stand unchallenged, but they have in fact been facilitating their regularization by assessing municipal taxes, sanctioning electricity and water connections, implied regulation by assessing municipal taxes, sanctioning electricity and water connections, and converting leasehold properties into freehold. At the same time, first issue, such like policies are in vogue in the states of Andhra Pradesh, Telangana, and city of Delhi, etc., etc. However, there are other states where the unauthorized colonies constructed decades back are suddenly ordered to be demolished with or without notice, but without any welfare scheme for rehabilitation of the persons of the families who are left of the affected families. It is in this backdrop that the petitioner contends that demolition being an extreme and irreversible measure cannot be carried out without a policy that reconciles enforcement of planning laws with the rights to shelter from a livelihood and dignity, as guaranteed under Article 21 of the Constitution.
Grateful, Lordship.
Next paragraph. It is in this backdrop that varied directions, as briefly pointed out at the outset, have been sought in this petition. Next paragraph. We have heard counsel for the petitioner at a considerable time. While we appreciate the concern of the petitioner organization regarding rehabilitation of those who are affected by those whose right to shelter is adversely impacted as a result of demolition, etc. But we are also of the view that such like issues essentially fall within the policy domain. The such situation may vary from state to state, and it may therefore warrant variation in their policy decisions as well. It would be difficult and may not be prudent for this court to lay down any uniform policy framework to be applied in all these states. Next paragraph. Contrarily, we deem it appropriate to dispose of this petition with the liberty to the petitioner to forward a copy of his petition to all the states, to Union of India, state governments and the union territories to consider the issues raised therein and raised therein for the purpose of formulation or revisiting their existing policies.
Grateful, Lordship.
We are hopeful that due consideration shall be given to all such issues by the competent authority. The petition stand disposed of in about.
We are so grateful, Lordship. We are so grateful.
Just kindly have this chart.
Okay.